Hello, everybody. It is 12 o'clock noon here on Wednesday, October 20th, 2021. I'm Dr. Mark Bronson, president of the Texas Board of Chiropractic Examiners. And today's meeting is a stakeholder meeting, an informal meeting. And we have on this call, on this webinar, we have 7 staff members and 22 attendees. One is a test attendee. So we actually have 21 guests plus our 7 staff members. The agenda for today is to, first, in a moment, I'm going to recognize Patrick Fortner, our executive director, and Christopher Burnett, our general counsel, to give them a chance to say hello and offer some introductions. And then I want to acknowledge everyone here. I want to acknowledge everybody's attendance and give you a chance to say hello. I want you to be comfortable with your microphone, and I want to encourage you to enter your comfort zone so that you can participate as you want to. The purpose and goal of the meeting, the purpose is, well, one goal that we have is to revise our prepaid treatment rule. And so we're soliciting input for that. And when we get to that, then I will call on Christopher to lead the discussion. And then the rest of the meeting, we're going to devote to hearing from our friends out there about the various business models. We just want to know what's going on out there and what's important to you. If you have any concerns, we'd like to hear about those. I am hearing some feedback from perhaps one of our participants, and I don't know where that's coming from, but it's coming back into my ears, my own voice. So let's do this. First, I want to go ahead and recognize Patrick Fortner and Christopher and allow you to say hello. And after you do that, and after we go around the table and let everybody test their microphone and say hello, then I want to share with you some recent data that I found from a poll regarding the profession, and that'll kind of set the stage for our discussions today. So, Patrick Fortner, good afternoon, sir.
Thank you, Dr. Bronson. Would like to welcome everybody to this stakeholder meeting. Obviously, because of the occurrences over the last year and a half with COVID, we haven't had the opportunity to do any other stakeholder meetings, at least in person. And when the opportunity to do this one came up, having it in person obviously wasn't a great option either. So we opted to go with this format. Hopefully, if this goes as well as I'm hoping that it does, we will be able to open up and have more stakeholder meetings moving forward, because the board has communicated to me and to staff many times that while they do keep up with their own research and try to have their own personal finger on the pulse of the industry and of the profession, they know that the stakeholders might have some interesting perspectives that need to be listened to. So again, welcome to everybody. Look forward to this discussion, and hopefully you'll be able to join us for more moving forward.
Christopher, good afternoon, sir.
Good afternoon, Dr. Bronson. Hello, everybody out there. I will certainly echo what Patrick said about getting input from folks out there in the stakeholder community. We do not claim to be the font of all information or knowledge, and certainly any input having to do with what actually goes on out in the field, so to speak, is welcome by us. And so not only in this context, but for anything else that the board has its fingers on, such as any rule revisions or any issues that come up. So please don't be hesitant to contact us about any of those things. Don't feel that you have to wait around until there's a stakeholder meeting. Specifically as to the intent of today's meeting, as Dr. Bronson mentioned, it's two-pronged. The first part is the board looking at a revision of 22 Texas Administrative Code Section 75.5, which is the prepaid treatment plan rule. A couple reasons for doing this. One is that in our massive rule reorganization that we undertook starting back in 2018, this is about the only rule that has not been touched yet. For whatever reason, the board's never gotten around to tackling this one. And we have an additional incentive to do that because under the Administrative Procedures Act, which kind of governs the way rules work for state agencies, there's a provision that mandates that state agencies need to do I guess best way to say it is a check on all their existing rules every 4 years. This one is far past the 4-year mark, and so to keep us in compliance with APA standards, we need to go through this exercise anyway. There's a draft. I believe we've shared that with everybody, or at least made it available on the website. And that's just it. It's a draft. So any suggestions or changes to what is in the draft version of a new rule will be welcome. There's no formal action that the board can take at this meeting. This is informal. It's not a formal board meeting, which means the board cannot decide that they're going to go forward with rulemaking. That would have to happen at a formal board meeting in which all the quorum of the board members are present. So we're still in the preliminary stages. Language can change. Board does decide to go ahead and engage in rulemaking on 75.5. That will be announced or will be done at a board meeting. The draft will be published in the Texas Register, and folks can then make formal comments on that and then go forward to whether or not the board is going to adopt it. The second prong of this discussion, as Dr. Bronson mentioned, is going to be looking at some business models that we've been encountering. And my belief is that this is information gathering only, just trying to figure out what exactly is going on out there in the industry, to get some perspective from chiropractors that are familiar with these models or have questions about them, etc. So sorry to be long-winded. That's what I've got.
That's quite all right. Next, I want to recognize Dr. Michael Henry, who is in the meeting. He's our board vice president and chair of Rules Committee. Hi, Dr. Henry. I think you might be muted, and I think maybe you can unmute yourself if that's the case.
I can. Everybody can hear me okay on there?
Yes.
Yeah. You know, I'm on Rules Committee, so these are near and dear to me, is trying to make sure that we have rules that function to serve all stakeholders, patients, providers, insurance companies alike, make sure that everybody is playing on the same playing field here. And one of the things we noticed is that there's been an evolution in how patient and physicians interact and other providers interact as far as fees. You know, we're seeing a lot of concierge and membership things, and it just wasn't really addressed in our rules. So one of the things I'd like to do is make sure that we have a rule that encompasses all fair and ethical ways of dealing with fees.
Thank you, Dr. Henry. We do have another board member on the call as a panelist, Dr. Deborah White. Dr. White, are you on the call?
Yes, sir, I am. I am able to see you and hear you and speak, but I'm unable to be seen for some reason. So anyway, that'll be just fine. Thank you for including me on this. And this has been very near and dear to my heart because we deal with a lot of cash patients, and we have prepayment plans that are available. And so I'm glad that we are, as a board, addressing this so that we can offer some continuity and some constructive instruction for our licensees.
Thank you, Dr. White. Joseph McLaughlin, our staff attorney, is also on the call. Hey, Joe.
Morning.
And then we now have 27 attendees. As I mentioned originally in this meeting, I'd like to unmute each of our attendees one by one, give you a chance to just say hi. If you would, just say hello and perhaps where you're from and who you work for. If you work for yourself or if you work for somebody else, just so we know who's in the meeting. And then later during the meeting, you'll have a chance to express your concerns. So let's limit this just for saying hello. Ann Glover. Oh, you are self-muted. Barrett McNabb. Oh, is Ann Glover? Are you there? Give you another chance. Just want to make sure we're not technologically challenged in the wrong direction. Are you there? How about Barrett McNabb?
Hello, this is Barrett McNabb.
Hey there, where are you from and who do you work for?
Yes, I'm a franchisee with the Joint Chiropractic, and I live and work in Houston, Texas.
Thank you for being here. Courtney Distasso.
Good morning, can you hear me?
I can.
I'm also with the Joint Chiropractic and the franchisees in the state of Texas.
Welcome to the meeting. Appreciate you being here. Dr. Cynthia Tays. Okay, I think we're playing mute, unmute. So Dr. Tays, there you go. Are you on?
Yes, I work for myself and I live in Houston and work in Houston.
Thank you. And former board president. Thank you. Thanks for being on the call. Erin Kelly. Okay, Dr. Kelly.
Hello, can you hear me?
I can now.
Okay, my name is Erin Kelly and I actually work for Dr. Brian Moore in Hot Springs Village, Arkansas.
Arkansas, welcome to Texas from Arkansas.
Thank you.
Appreciate you being here. Grace Rollinger.
Hi there, this is Grace Rollinger. I work for the Joint Chiropractic in Houston, Texas, supporting our franchisees in the state of Texas.
Thank you for being here. John Dugie. I'm going to get you to pronounce that for me. Is it Doogie? I have you unmuted, and you might need to unmute yourself. I don't know. Okay. I'm going to go ahead and mute you and move on. Here's Josh Massengill. Hey, Mr. Massengill.
Hi, thanks for having me here today on behalf of the Texas Chiropractic Association.
Thank you for being here. Kyra Tanwar.
Hi, this is Kara Tanwar. I'm the Executive Director of the Texas Chiropractic Association, and thanks for having me today.
Oh, excellent. I appreciate you being here. And your first name's pronounced Kara.
Kara, just ignore the I.
Okay, thanks for attending. We appreciate you. Kathy Jones?
Hello, I'm Kathy Jones with NACA, Texas, and I am so glad you're addressing this because this is a problem I hear from the doctors all over Texas constantly. Thank you.
Well, I appreciate you being here. I'm looking forward to hearing from you. KD Dillon?
I work for myself here in Houston.
Thanks for being here, Dr. Dillon. Kelly Moore?
Hi, I'm Kelly Moore. I'm a chiropractic assistant. I have been for about 25 or 6 years, and I'm a compliance consultant. I teach compliance, documentation, coding, and billing.
Yes, you do. Thank you for being here, Kelly Moore. I appreciate you. Kevin Lees?
Good morning. Kevin Lees. I work in Scottsdale, Arizona for the Joint Chiropractic. Thanks for having me.
I appreciate you being here, Dr. Lees. Corey Rose? Let's try again.
Can you hear me now?
There you go.
Yeah, I practice for myself and live in New Braunfels, Texas. I'm also the State Affairs Committee Chair for the TCA.
Thank you for being here. Appreciate you. Dr. Larry Montgomery.
Larry Montgomery, Belton, Texas. I'm under the illusion that I work for myself also.
Thanks for being here, Larry. Matthew Kolker.
Hi, my name is Dr. Matthew Kolker, and I'm a chiropractor. I work for the Joint in the Dallas-Fort Worth area.
Thanks for being here, Dr. Kolker. Michael Knott.
Hi, Mike Knott here. I work for the Joint in Temple, Texas.
Thanks for being here, Dr. Knott. You're a DC, right?
Yes, sir.
Thank you. Dr. Michael Shepard.
Yeah, Dr. Michael Shepard. I'm the Chief Academic Officer for Texas Chiropractic College, and I work for my wife.
Likewise. Thanks for being here, Dr. Shepard. Appreciate you.
Good to see you, Mark.
Michelle Quattlebaum.
Well, good afternoon now. I'm Michelle Quattlebaum. I'm an attorney and I'm based out of Houston, but I represent doctors all over the state, not only in front of you guys, the board, but in malpractice cases. So thank you for allowing me to join you.
We couldn't do it without you, Michelle. I appreciate you.
You
being
always
here.
may regret saying that. Thank you.
Well, let me put it this way. The meeting wouldn't be the same without you.
Oh, that's true. That's true. Thank you.
Michelle, remind
Yes,
me,
sir.
do you represent anyone on the dental or medical field, or is it just chiropractic?
No, I do all medical, dental, nursing, nurses. So probably in front of most of the boards, TDLR, the nursing board, and then malpractice for them all too.
I was just trying to remember. Thank you.
Yeah, thank you. Mhm.
Scott Kelly. Scott Kelly, are you there? You are self-muted. I see your hand raised, but just know that you are self-muted, and if you can find the button to unmute yourself, we love to hear you say hello. And we're going to move on to Dr. Scott Wofford, is our board secretary and member of the enforcement committee. Dr. Wofford, are you there?
Yes, I am. I just want to thank you for being here, and I'm very encouraged about this meeting, and I would like to reiterate what Dr. Michael Henry said, and I think it's long overdue that we address this.
Dr. Wofford, thank you for your service on the board, and I appreciate you being here to participate.
Thank you.
Steve Knopf.
Hi, good afternoon. I'm Dr. Stephen Knopf. I'm a professional member with the Arizona Board of Chiropractic Examiners and immediate past vice president with them, though I don't represent them here today. I also serve as the executive director of chiropractic and compliance for the joint corporate office out of Scottsdale, Arizona.
Thank you for being here, Dr. Knopf, and I appreciate that you do pronounce the K in your name.
Yes, thank you.
Summer Kotson or Kotson?
I'm Dr. Summer Kotson, and I work for myself in San Antonio.
Thank you for being here. Travis Prothro.
My name is Dr. Travis Prothro, and I would like to thank y'all for the open invitation to participate in this process. I see a lot of familiar faces and names and voices, so I just wanted to thank everyone for the opportunity to kind of speak on our behalf for our model. And I just wanted to give a big shout out to all our H-Town representation we seem to have going on in the meeting.
Dr. Prothro, thanks for being here at this meeting. You had attended another stakeholder meeting that we had in person, and I guess that was been a couple, 2.5 years ago, maybe, on documentation. So thanks for being back.
No problem. It's a pleasure to be back again.
And let's move along with our agenda. First, before we do that, I wanted to share some data with you all that came to my attention. I was looking at the ACA forum that comes to my email, prompts me, and so then I just go to it and see what people are talking about. Here's one topic that is perhaps relevant to this conversation, and I'm going to share this with you. There are, when I first started in practice, and some of you, we had two kinds of chiropractors. We had the straights and the mixers. Straights being subluxation-based chiropractors and not employing any additional modalities into the practice. And then there were the mixers who added ultrasound, electrotherapy, nutrition, perhaps, and other things. And so there were two groups. Now I understand that really there are three types of chiropractors acknowledged by our researchers. And I'll share with you what I found. I'm not going to share the names. I didn't even write them down, but I did write down what they said. Recently published survey of the chiropractic profession in the US. Of the 91,000 chiropractic licenses issued in the nation, the authors of this study randomly chose almost 9,000 and received just under 40% responses, which is quite large for a survey. The question was to identify the best role for the chiropractic profession within the greater healthcare system. The majority of the respondents, 57%, identified spine and neuromusculoskeletal care. The remainder chose general primary care, 22%, or vertebral subluxation detection and removal, 21%. One colleague commented, what the current survey substantiates is that there are three major focuses in the profession, and each can find success. as they have been doing for 100 years. In 2003, McDonald published a book about the profession based on his survey work called How Chiropractors Think and Practice. Institute for Social Research, Ada, Ohio, and found essentially the same thing. 47% were neuromusculoskeletal, 34% broad scope primary care, and 19% focused scope on subluxation only. And so here we are 20 years later with essentially no change. And my note is actually there has been a 10% shift to spine and musculoskeletal. The same colleague on that forum added, quote, people seeking a healthcare practitioner will often choose someone who is aligned with their own value system and worldviews, and often that is not based on evidence but on beliefs. As long as the practitioner doesn't misinterpret the facts or break the law, so be it. This is still America, right? All right, with that, I am going to go ahead and call on Patrick and or Christopher to lead the discussion. We want you to, we want to make sure that you get what you need from this meeting. And during such, I will look for hands raised and call on our attendees as appropriate to make comments. I'll try not to skip over you. And I think Nikel is helping out behind the scenes and can let me know if I miss somebody. So here we go.
Dr. Bronson, I appreciate the consideration, but since this is involving, discussion that will end up delving into possible rules, I am not a lawyer, nor do I play one on the internet, so I'm going to defer to Christopher.
Thank you. Okay, well, I guess I better start off this way, just to calm any nerves out there. The review of 75.5 is for the reasons I stated earlier. In my view, the current rule, I'm not saying that there's any deficiencies in there substantively. The problem with the rule right now, from my vantage point as being the rule guru, is that it's not very well written, and the language needs to be cleaned up. So with that in mind, what I did was to take the current rule and put it into what I think, at least I hope, is somewhat easier language for everybody to read and to understand. So I don't think I made any substantive changes, with one slight exception. And that is, under the current rule, we talk about licensees engaging in entering into a prepaid treatment plan with a patient. I have changed the wording of that in the draft to make it between an individual or person and a patient, taking into consideration those instances in which we may have a non-chiropractor clinic owner, that they are going to be responsible for the terms of any prepaid treatment plan, not just a licensee. But other than that, I think substantively it remains the same as the current rule. Now, I have not heard from anybody specifically on any specific issues that they have with the substantive provisions of the current rule. Now, I had a brief chat with Michelle yesterday. There may be some issues that she's got, which I would love to hear, see if there's anything we need to do to change the language around in the draft to address those. And certainly Norma and Joe could probably chime in for anything that they're seeing on the enforcement side that deals with prepaid treatment plans. But I just wanted everybody to be aware of that has been no urgent reason to do any changes on this rule, other than we just need to clean it up. and get us into compliance with the Administrative Procedures Act. If anybody's got any questions about that or comments about the draft or the current rule, problems with that, this would be a good time to hear those.
So I'm going to scroll through and see if I see any hands raised. I do. I see two. Michelle Quattlebaum. I still can't hear you. Now,
Okay,
here you go.
now I unmuted. Okay, from Christopher and I talked briefly about this, and thank you for providing me a copy of the proposed rule. I'm kind of visual, so I have to read it. My concern, of course, my perspective is how I clean up after the fact if there's been a complaint or a doctor who has been alleged to have violated any rule. And from talking with Christopher, he has said, you know, you're not really changing any of the substantive part of the rule and changing it, but the wording of D in section D, it's changed. And he says, well, that it's meaning the same, but I'm anticipating, I guess is the proper word, that might be interpreted differently. The reason is it used to say that it's about refunds. And actually, you know, I've been around the sun many years, I mean, many times. And when the rule first came out, the problem was that there were so many complaints about the refunds. And what was happening was the doctors, when they would refund, say, well, yeah, the money you paid was the discounted amount. So when we refund, we're going to charge you our regular rates for what you've already incurred. And then the patient would feel that they were not being refunded a proper amount. The board changed that because they agreed. I mean, that was my understanding. So you instituted this rule it's been about probably what, 8 or 10 years ago, and said you would do it in a pro rata basis. But then the way D says now, it's minus the cost of any services or goods already provided. So what I'm hearing from y'all is that this is supposed to still be the same intent, which is that they will be the patient will be refunded the money they paid from what they were paid, and they won't be able to extract a different value. And I'm concerned with that phrase, minus the cost of any services, that some of my clients might interpret that as, well, the cost of the service is much more than what you actually paid. And so therefore, we're going to cut that out of the refund money. And so that is just, maybe I'm being hypercritical, but I see this from the backside, and I know how people interpret things. So that was my only problem, is I'm not sure now if you're intending to change this and allow them to charge extra on the refund, the doctors not refund as much as they paid, and so that's my concern with subsection D.
Michelle, I think that's a good point. And I think we can come up with some language to insert in there, maybe previously agreed cost, something to make it definitive that you're talking about the cost that was agreed to in the prepaid treatment plan.
Yeah, I'm not making a position of what it should be. I'm just saying that I read into it some, it's open to interpretation. And I have found that interpretation leads us all over the place. And so I don't want to be in front of you guys having to defend my doctor's interpretation of that rule. So that's my only concern with D.
When we're drafting this, I'd also like to consider language to just talk about it, our standard published rates for when you're considering any kind of refund, because there's some differences there, and we'll get into it in the committee side of it, but let's make sure that we do look at that one.
Okay, great.
Thank you, Michelle.
Hey,
Very
Dr.
good
Bronson?
insights.
I'd like to ask before we, just to make sure we don't run out of time. I know that getting into the language on a draft is something that if we have time, it'd be great to look at some different options, but I wanted to make sure that we're not missing any different models out there that we're not aware of. So if you're okay with it, I'd like to just kind of run down the models that I'm kind of considering as we do this drafting process and see if there's someone out there who might have something totally different I hadn't thought of yet.
Oh, sure. I have, I'm looking at 2 hands raised.
It has
Dr.
to do with
Henry.
wording or language on a draft. I'd rather wait on those if that's okay. So if you're raising your hand to critique language on the draft, there may be some other drafts coming out, so it might not be worth spending our time on that at the moment.
Okay.
And Dr. Bronson, to accommodate Dr. Henry, what I would suggest is that if there's any of the participants that have any concerns or issues with any of the specific language in the draft, to just go ahead and email those to me, and we'll start circulating those around in our little informal way, and see if we can address those that way, and that's allowing Dr. Henry to get the information he wants about the other services out there.
Yeah, I'd like to focus kind of on the bigger picture than the language, just because the language is very likely to change quite a bit as we go through this if there is something different going on.
Okay, good idea. So we're not going to be doing committee work here right now. But yes, I agree. We want to give everybody a chance to speak with the larger picture.
And once we have language, that will obviously be published where we can take comment from the public through our normal process. But to get a good draft, I want to make sure we have the info. So, the models that we're kind of looking at are your traditional pay, a certain fee as you check out every single visit model, which is kind of the more old school. It's the more traditional way that you see in a lot of healthcare practices. If you have known co-pays and things like that, the traditional prepay model, from what I understand, is geared more toward cash services that you can say a definitive price versus an insurance services where you don't know till you get EOBs back for sure what's being paid. So it's kind of a non-reconciliation. It's an agreement where it is a set price for an adjustment or whatever service you're giving, and you're giving out a certain number of them, and you can pay up front for a certain number of services, not necessarily on a timeline, but just a set number or amount of service. And so I think that's kind of the traditional treatment plan or prepaid treatment plan model that our current rules written toward. At least that's kind of the way I read it. There's the insurance prepay model, which is where you have a cost estimate up front on what you think is going to be paid. You can get a discount, or you can pay up front, or you can even pay out. I know there's a lot of people who allow financing and other things involved with prepayment, but it's based off of a cost estimate, including insurance coverage, so that cost may change. And so as we write rules, we want to be sure that we don't write any of our stakeholders into a corner committed to a price that may not be the actual price, because as we all know, insurance companies don't always pay exactly the way that you think they're gonna. So something to consider is it's not quite so cut and dry on that everything is exactly what price. That's why if you're going to do things as an estimate, we need to make sure that that's still allowable. There's the membership model, which is kind of a newer one. The membership model, the way I understand it, is it's not necessarily a set number of services. It's really based more on a time. So it can be a set number of services, but it's a use it or lose it kind of model. And I know that there's some docs on this call who practice a membership model, and I would love to hear if I have this wrong, or if I don't fully grasp it, or if there's an angle I haven't thought about. But the membership model can either be for an unlimited amount of service or for a specific number of services over a certain time period, either monthly or semi-annually or annually, from my understanding of it. And so, I'd love to get some feedback on the membership model side, since that is something a little newer that I don't have as much experience with. And I want to make sure our board has as much information as we can get on the membership models. And then the concierge models, I've seen a couple of these where it's either an annual fee that does include some service with that fee, or it's an annual fee that allows you access to a provider, and then you still pay per service on top of that. And I don't know if that even falls under a treatment plan, since there's no necessarily plan associated. It's really an access fee. I just want to make sure that we're considering the concierge model too, especially the ones that do include some services and not others. So membership, concierge, traditional prepay, insurance prepay, which is cost estimate, and then pay at time of service are kind of the big payment models that I'm aware of and kind of working from. So if anyone on the call has some insight on some models we haven't thought about or is doing something different that we might not know about, I'd love to hear some feedback on that.
Excellent. I'm going to call on Scott Kelly and to see if you have something to add to that. Scott Kelly. You had your hand raised, so I called on you. Let's move to Steve Knopf. Steve Knopf, are you there? Nope. You've had your hand raised for 6 minutes, I see, and I'm going to lower your hand and give you the floor if you need to talk.
Thank you. It seems you're discussing a draft proposal. Do you know where that draft language is available for the public? If it is available for us?
If you're talking about the draft for 75.5 that we're looking at already on the board's website, it's available. Let me get over there just to make sure I'm telling you the right place. Well, I may be wrong. We put the current version, but not the draft version up. That is my mistake. That is no big deal, however. I will fire a copy of that over to Nikhil, and I think we can get that up on the board website here fairly quickly.
All right, thank you.
Nikhil has something else to say about it.
Okay, I see on my dashboard, I see a question mark beside the name Larry Montgomery. Dr. Montgomery, did you have something you wanted a question to ask? Oh, no, it says I'm supposed to go to the questions pane. I'd rather you not write anything to me because then I have to go and read it.
It was just the same question that was just asked where we could get a copy of the draft.
Okay. Right, thanks. And now let me go down to Travis Prothro. Dr. Prothro. You're muted still. I'm still seeing that you're muted. See if I can do anything about that. No, it says you're self-muted.
Oh, there we go. Yeah, I just wanted to comment on the insight that we had because that was actually going to be one of my recommendations. The current rule is actually a little bit antiquated in that it's written for kind of fee-for-service type models. It doesn't account in for value-based units such as capitation models or more of the concierge style services. Just to kind of describe the differences between those two, the capitation style model is that model that was referenced earlier in which a provider is typically paid a set value amount for a per capita rate, such as a per person per monthly rate, and that doesn't dictate how much care or services are rendered. This was designed as a value or a financial risk sharing model in which the provider takes some of the financial risk compared to the entity making those payments. It's slightly different from the concierge service, which basically dictates that they get paid the access rate, but then they also bill same as they would in a fee-for-service model to actually recuperate those dollars for services rendered. And so the current rule actually doesn't really do a good way about identifying and how to handle those current models. And I think that kind of taking those into consideration might be a good idea.
Thank you, Dr. Prothro. Does anybody have any questions following that advice?
Dr. Bronson, Scott Kelly has been able to unmute now.
Okay. Let me go back to, I'm scrolling through the list, so 'cause I want to find. Okay. Oh, so I just muted you. No, you're unmuted, Dr. Kelly. You have the floor. Scott Kelly. I'm hearing a little static coming through. I'm not sure if that's you, Dr. Kelly, or if that's from another source. I do also see a question mark. And again, I'm not reading questions that come in. I don't even know where that is.
He just put a
Oh,
question in there, Dr. Bronson, that his microphone is not working.
Not coming through. Okay, I did find that now. So I saw that. That's too bad. If y'all get it working. Now, by the way, we are scheduled to be meeting from 12 noon until 1:15. So we have actually another 29 minutes to meet here according to our schedule if we need to. So plenty of time for everybody to weigh in.
You know, that was very helpful hearing the difference between the capitation model versus the concierge model. I hadn't differentiated that, but I assume those are just two different kinds of membership models, kind of looking at that. Is there anyone who has a model that we haven't talked about? That's really kind of why I wanted to get as much input as we could, is what other models are there out there?
Okay, I have a hand raised. Cynthia Tays. Dr. Tays, are you there?
Yes. I have a legal question. How do you determine when something is a capitated model that's legal and when it is not legal due to insurance laws?
Well, Dr. Tays, that's a good question. And, you know, part of the problem is when you're talking about the insurance issues is that that's not something under our jurisdiction. So, and to be honest, it's not something that I wouldn't be comfortable, and I doubt if Joseph would be comfortable giving an opinion on, because our opinions really don't count. So what that distinction is, I couldn't tell you right now. I mean, that might require us to do some chatting with our dear friends at the Texas Department of Insurance to make sure that what that distinction, does it cause a problem? I don't know.
I know that I've looked on the medical board's website as well as the dental board's trying to look for some guidance on some of this, just because the dental board's been doing, you know, they've been doing cost of care estimates and payment plans since the beginning of orthodontics for kids, as far as I know. I mean, I think I remember in the 80s that existed. So they've been lots of experience with it, but I couldn't find any rules on the board getting involved with how doctors and patients negotiate fees or collect fees. And on the medical board, I didn't have much more luck, even though I know that the medical industry has shifted a whole lot toward the concierge, you know, MD, VIP, large companies like that are doing quite a bit of the concierge service where you pay a fee and then you still have payment on top. You know, I would be concerned about taking insurance and you doing some of these models at the same time. I think you could run into that, but I think that's very contract driven as to what your contract and the insurance company's agreement is.
Dr. Prothro. Unmute your microphone and share your thoughts with us.
Thank you. So a lot of the rules and regulations for these do fall under guidelines for managed care organizations, and you can find a lot of the stipulations under there. But you are correct in that most of them are governed by the contract laws for insurance companies. The problem with a lot of the capitation and concierge services is that's just two flavors that you can actually get of these value-based payment incentive programs. So to answer your question, there are actually, I think, countless dozens types of services for reimbursement models you can actually take into consideration. The question is, chiropractic as a paradigm has always been a little bit behind what a lot of what we're seeing in the medical institutions, such as hospitals, full clinic services. So which one of these are starting to bleed over into our profession at a much higher and larger rate? I do know that we are starting to see a lot more capitative models. We are starting to see a lot more concierge-based models. And some of these we can necessarily ignore because we don't see some of us utilizing the same services, but I think the board would probably would be doing their due diligence to kind of consider some of the more profound models being used in the healthcare sector, such as hospital settings, clinics, because I assume that we're going to be seeing a lot of that being pushed into our sphere here shortly, with a lot of the shift going towards value-based care being dictated by Medicare services.
Sorry, my camera seems to have decided to go on the fritz here, but I'm still with you. Yeah, and actually that's one of my concerns writing this rule is I want to make sure that we are thinking big picture. So maybe some broader restrictions as far as clarity on communication with patients and clear agreements may be a better option than trying to specifically write rules for each model that's out there. And that's something we're going to look at at a committee level.
Dr. Bronson, this is Dr. White. Can I ask a question?
Certainly.
And it's somewhat of a statement as well. My experience has been that with our current licensees, the majority of them are concerned about the prepay plans relative to unmet deductibles and even copays, and how that relates to the TDI rules. So their apprehension about prepays seem to be revolved around those two subjects.
Okay. Dr. Henry, do you have a comment on that?
Yeah, it's common is that I think there's some confusion on just because the board allows something doesn't mean that your insurance contract does. It is not the board's job to, or even duty or right to come in and try to dictate what you do in practice and what you agree to with an insurance contract. So TDI rules, that's between, I mean, there's some law there, but it's also some agreement between insurance companies, and you can be in breach of contract if you do set up some payment models. That doesn't mean that your neighbor down the street who doesn't take insurance should be written into the same rule. So when we write a rule, it does not mean that it is okay to do what we're saying you can do if you have a contract that says you can't. So it doesn't supersede those rules. So that's what I always advise people when I hear that question, is that I would reference your contract.
Thank you.
Okay, thank you, Dr. White. Kelly Moore.
Hi, yes, I just wanted to maybe weigh in from a compliance point of view based on Dr. Tase's question about the legalities of capitated plans versus prepays when it comes to insurance. And what I would do is revert back to, I found an opinion published by the Government Accountability Office. It's a 2005 opinion, and it's right around the time that a lot of concierge services were coming about. And it was meant to address the problems that arose from doctors' offices, hospitals, clinics, the problems that they were getting into as a result of going to that concierge model. And basically, they came out and said in that opinion that HHS, Health and Human Services, has determined that concierge care arrangements are allowed as long as they do not violate any of Medicare's requirements. For example, the membership fee must not result in additional charges for items or services that Medicare already reimburses. So we could take that principle that as a guidance for and put any other insurance company in there. As long as you're not violating any of your other contracted rules or state or federal rules, then that should be the guidance. So in going forward and kind of fleshing out this, any changes that may need to be made to this rule that we're discussing as far as prepaid plans, I think it's really important to make definitions of what is a capitated plan and what is a subscription-based plan, or I think Joint calls it a membership. What are those exactly, so that our providers and offices can apply these rules and be very safe from a point of view of knowing exactly where they stand, and making sure that we can take what's outlined in the rule to be positive that we are not violating any of the other state and federal rules as far as discounts for co-pays, deductibles, or any other covered service. If you go back and read this article or this opinion that I mentioned earlier, it specifically says those covered services. So we don't want the patient having to pay twice. So that is my 2 cents worth from a compliance point of view.
Oh, I think that's worth well more than 2 cents. And I think that our staff and rules committee would appreciate you to send some suggested wording even that they might consider for drafting the rule. Am I right, Christopher?
Yeah, Dr. Bronson, I just want to be clear about one thing here. We're talking about 2 separate agenda items here. One is the revision of 75.5. That is one thing that is being considered. The other thing is all the other business models that we've been talking about, capitation, membership, that's a different area. So when we're talking about changes to the prepaid treatment plan rule, the current rule, we're not talking about shoehorning all these other business models into that existing rule. If there's a need, and this is a policy decision for the board to make, if the board determines that there is a need to do some sort of rulemaking to address possible issues with the other business models, capitation, membership, concierge, that's down the road. And that's something that's going to be.
So Christopher, when we're drafting, oh, sorry.
Yeah. Also, it comes back to me, I'll bring it up again.
There's a lot of background noise, so if anyone who's not talking can mute, that would be great. But I think when we draft, I think one of the first things we need to do is just clearly define what is and isn't considered a prepaid treatment plan. I think that would solve a lot of the problem here, is saying what is a prepaid treatment plan and what isn't as we work on 75.5. I think that'll help us a lot.
Okay, now I remember my final point is that in terms of rulemaking, and we're doing something that deals with pretty directly with economic activity. This will put us under the purview, I guarantee you, of the Governor's Regulatory and Compliance Division. So we'll have to be exceedingly careful about how we draft things. And one of the overriding questions that has to be looked at by the board when thinking about, well, do we actually need to do a rule, is what is the evil that the rule is designed to address? And it's got to be pretty specific. So I don't want you all to think, and by you all, I mean the board, to think that you have to do a rule on these alternative business models. Maybe not. Maybe just simply the discussion here is going to be sufficient, but there's no requirement that you do so. And if you do decide to go down that path, we're going to have to be extremely tailored and narrow in whatever that rule looks like, because we're talking about something that directly affects the economic bread and butter of the licensee community. This isn't just something, this isn't like a checklist on how to close your practice. You know, Their big thing is, does it have market impact? Generally, I scoff at their definition of market impact, but I think here you're talking about something that absolutely will directly affect the economics of our licensees. So just please keep that in mind.
Thank you, Christopher. If our staff and board members are attending, if you wouldn't mind, let me recognize a few people that have had their hand raised. I'm going to give Steve Knopf another chance. Let's see if that works. I'm going to unmute you, and it looks like you're self-muted. Steve Knopf, you are self-muted. If you want to talk to us, look.
Yep, I'm here. Thank you. Yeah, I just want to agree with what was mostly said, and with my experience across other boards. First, as it pertains to contracting with any third-party reimbursement, whether that's on the federal or state level, there's often contract language around what you can and can't offer, as well as still be qualified to receive reimbursement through those parties. And often when I'm discussing this point with chiropractors and other boards, they feel that it's not in their purview, as Christopher mentioned, to try to get in the middle of that relationship, and they should just figure that out between themselves. Now, if you're not contracted with these parties, to the points that were already made, often what you see, if there is board language for what I'll just call direct pay contracts, meaning contracts established between a chiropractic business provider directly with the patient to pay the provider for services. If there is any language in the state board, what you typically see are two items. Again, the idea of a board is to protect the patient or the consumer. With that in mind, what you typically see for provisions is terms around what services or goods are provided with the prepayment, as well as terms for refunding any unused money. And that's about as far as it extends. Because when you're trying to think about what evil are you trying to protect from, it's really taking advantage of your patients or consumers, having convoluted language, or trying to overcharge for things that they didn't know that they received or should have received. And those are the two typical terms that are outlined in direct pay contracts. And then finally, I agree with Christopher when you think about rulemaking and its economical impact to a provider. This is one that has the potential to make a material difference to a clinician, a chiropractic business, or other healthcare provider. These models are becoming more and more prevalent, and so the Texas board is certainly in a critical position, especially with how big you are and how many providers you have in your state, since a lot of states look to Texas as a leader for really these rules and regulations. So what you decide here certainly just doesn't impact Texas, but potential other board decisions as well. So I hope you just, and I know you will, keep that in consideration.
Yes, sir. Scott Kelly. Dr. Scott Kelly, are you there? Looks like your microphone is live, so go ahead and share with us whatever you have. Let's see, anybody else? Dr. Prothro?
Thank you once again. I feel like I'm not overutilizing my time. I just want to emphasize again the importance of the capitated model, which again is what we see in a lot of these membership-based models. The design of it is ultimately as a value-based compensation model, meaning that a lot of times whenever you agree or enter into a contract to do this type of reimbursement, is some of the financial risk is actually shifted to the provider, understanding that they're getting paid the exact same dollar figure no matter if a patient gets 0 visits or if they use 100 visits, let's say. So the current rule as it stands, what it would actually do effectively is give that provider all of the financial risk and none of the availability to leverage the model of capitation to basically offset the cost of those individuals not utilizing the full breadth of their services. And so what you're going to see is under the current rule is a lot of these providers using a capitative model under the current subset of rules is that they would end up absorbing a lot of additional extraneous costs, resulting in a moral hazard, passing along higher rates to the patients, and it defeats the purpose of the value-based model. What I would strongly encourage is that the biggest thing we need to look out for these is that the patient needs to be informed that they understand the type of model they're entering into, and they need to be informed and understand the way that reimbursements or refunds or what have you is executed. But ultimately beyond that, it should be just simply subject to the terms of like the actual contract law. I don't think that trying to make a one-size-fits-all rule for the capitated versus the fee-for-service type models is going to actually be a fruitful endeavor. You're going to end up having two starkly different compensation models conflicting with each other just by the nature of how they work. And then you also run into the issue of the same type of problem when you're starting to look at bundling type reimbursement models, when you're starting to look at some of the concierge reimbursement models. The whole point of those models being created was so that you could take some of the cost and shift it from the underutilizers to the overutilizers to basically impart a somewhat savings to the patients that are engaging in them. And so long as the patients are understanding of that fact, they're benefiting from the additional reduction in fees because maybe they're not needing as much care or what have you. And that's one of the things that we need to kind of keep in mind is that if you're going to end up creating a rule that basically cuts that short, you're going to see that it's actually going to harm both the provider financially and thusly be carried on to the patient ultimately in the form of higher costs and the availability of less affordable chiropractic care.
Thank you, Dr. Prothro. Let me scroll through our attendees and see if I see any other hands. Anybody else? Any staff members? Norma Rodriguez, I see you back there on Joe's cam. I didn't recognize you individually earlier. Do you have anything you want to add?
One thing I wanted to add is that it would be helpful for the chiropractors to be specific on what items that they might be selling, whether it be braces or supports or equipment, what items in particular are non-refundable and at what point are they non-refundable. I know that we want them to be able to spell out whether it's included in the price for the prepayment treatment plan, but also to be able to be clear for the patient to know once they take it home, does it now become non-refundable or do they have a waiting period of a couple of days to be able to return it?
Just so our audience knows your perspective, Norma is our Director of Enforcement, and so she's directly involved with complaints that come in. So thank you for those insights and those concerns, Norma.
I wanted to add one more thing. From time to time, we do receive some complaints where the consumer has entered into a contract, but in the contract, they've written in there that they are prohibited from filing a complaint, that they must use some sort of internal mitigation or some other kind of mediation.
Like an arbitration clause or something like that.
And so the consumer becomes very frightened to be able to move forward with a complaint with us because they're afraid of being sued directly by the doctor. So one thing that I would want to maybe have us consider is maybe that we write in there that they cannot write in there that they're prohibited from filing a complaint.
Thank you very much. Thank you, Joe. Thank you, Norma.
Thank you.
All right.
Dr. Bronson, her hand is not up anymore, but Kathy Jones had her hand up for a minute. I don't know if she's still on the call or not.
Kathy Jones, if you're on the call, I unmuted you and you are self-muted if you'd like to. There you go.
I'm still here. I just have one suggestion, and I'd like to hear more from Norma and Joseph on all the complaints we've had on these prepayment plans. I know what I've seen in my office. And I've got doctors billing insurances and the patient on the prepayment plans. This is ridiculous. Something needs to be put in the prepayment plan that they cannot bill the insurance, the network that they're in, unless it's a non-covered service by that network. They can't bill for the patient the copays and take a discount on it because they're breaking contract law when they're in contract with the network that they agree to accept that copay at a certain price. So, you know, I've seen this a lot. So maybe something in that prepayment plan that they cannot bill the insurance companies that they're in network with unless it's non-covered. And I love the idea of the concierge and the membership because I hear that all the time. Please make rules, guys. Thank you.
Thank you, Kathy. I appreciate your input. Okay, we're closing in on 1:15. I have 1:11. That leaves us a couple of minutes if we stay on time. Dr. Henry, Christopher, Patrick.
I'd just like to thank everybody for the feedback. This has been helpful for sure. I've gotten some good ideas out of it, and I think it'll help us draft a better rule. So thank you guys for participating. And ladies, of course.
I would just like to say that if you have any specific language issues, again, on the draft 75.5, once you get a copy of it, again, my apologies, feel free to just email me, christopher@tbce.texas.gov, and we'll take it from there.
With that, if there's I'm going to recognize once again Steve Knopf. Your microphone is live.
Thank you, Dr. Bronson. I understand that there's draft language for the prepayment rule. Is there a timeline around the decision if additional rules or language need to be constructed for memberships and concierge plans? And if there is a timeline from when you might contemplate making that or drafting that, when do you think that would be?
There's no timeline set. The way the rulemaking process goes is that if the board determines that they do want to do rulemaking, the proposed rule has to be, the board has to vote the proposed rule for proposal for publication in the Texas Register at a formal board meeting, which means it'll be on the agenda. And people will have advance notice of it. Once it gets published, if the board votes to do so, then there's a formal 30-day comment period, and then the board has to wait until basically the next board meeting to whether or not to adopt the proposed rule with or without substantive changes, non-substantive changes. And then 20 days after publication from that date, the rule would be final. Prior to that formal Administrative Procedures Act process, it's board can talk about it and chit chat and pass drafts around all it wants to, and there's no statutory timelines involved whatsoever.
Okay, thank you, and thanks again for holding this meeting. We appreciate it.
Yes, sir. So to be clear for everybody in attendance, we encourage you to look at the agenda when we post it before a board meeting. And on that, you'll see a list of proposed rules for consideration. And then in the next agenda item is always going to be a list of rules for adoption. So the board can take action on either proposing a rule or adopting a rule, and and then move forward. Kelly Moore.
I just wanted to say that I'm happy to go ahead and put together a couple of references for you as you had asked prior to get that together. When would you need that by in order to consider this for your purposes here today?
Depends on the content. Christopher?
Well, again, we don't really have any timelines. If you're talking about just kind of general information having to do with these business models, whenever you get to them, I would say, you know, not immediately, but certainly while the topic is fresh in everybody's mind, it would be best to get those as soon as you could, but we're not stuck with any timelines here.
Also, following up with her question, then Christopher, say if we're going to consider a rule proposal here in the next board meeting, then when should she have her information to you?
Again, well, the next board meeting is, let's see, when is it? November. So
November 19th.
Yeah. So prior to the board meeting, I'd say optimally 2 weeks prior to a board meeting, because that's usually when we send information, all the board meeting materials to the board members so they can have plenty of time to review all that. And it's not just, it's because they're looking at things above and beyond just rules. There's enforcement actions, there's some policy discussions, a bunch of other things. So if you want to give the board a leisurely amount of time to be able to consider whatever it is, 2 weeks prior to the board meeting would be wonderful.
Yeah, so ideally maybe around the 1st of November. The meeting is scheduled for the 18th, Thursday, November 18th.
Dr.
Okay,
Bronson, before we go, Norma and I just wanted to add, and really actually to support and reiterate what Kathy Jones just said a couple comments ago. We do in complaints tend to see a lot of confusion on behalf of the consumer, the patient, the person who's filing the complaint. What exactly is being covered by their insurance and what exactly isn't, and so what exactly they're having to pay for out of pocket. So in the event that we do take some type of rulemaking action, whatever form that takes, that's something that we would maybe want to see addressed. I don't know exactly the mechanics of how that would look. Again, that's more committee level discussion, but that's just something that we wanted to go ahead and express while we had the forum.
So in other words, I think what you're saying is that many people that are filing complaints think that their insurance is covering something when in fact either it doesn't cover it or the doctor isn't filing. Is that how it goes?
Actually, what the complaints have been is the patient pays like $3,000 up front for the prepaid treatment plan, and then the doctor also submits insurance. So the patient's actually been paying twice. So then when we get the response from the doctor might say, well, I didn't think the insurance covered this, so I didn't submit that to the insurance. When in reality, they should have submitted that to the insurance, whether they paid it or they denied it. The patient had that opportunity to make that appeal. But the long story short is they've paid the prepayment plan and they're paying through their insurance. So sometimes we have some confusion, perhaps on the doctor's side, on what they're actually supposed to submit or what the prepayment treatment plan should be used for. And it was my understanding that it was really to cover what the insurance does not pay. But you've got to submit it to be able to get that denial and then recoup that money.
So are these docs not refunding the patient the difference?
We've had some problems.
That may qualify for some other penalties from some other areas as well.
Yes, sir.
Okay, Dr. Prothro. Okay,
And I just wanted I just wanted to reemphasize, I know you had some questions, Dr. Henry and Mr. Christopher, about some of these membership models. And if y'all did want some additional assistance on exploring some of those other reimbursement avenues, as well as like how they operate in the medical sphere, I offer my assistance. Just feel free to reach out. I can help in any capacity to help draft some of that language.
Appreciate that.
Thank you,
I'd
Dr.
also like to ask
Prothro.
everyone on this call to keep an eye out for when this rule does get posted, because we do have a mechanism in place where we can get specific comments on the language once it's been published as to what we're proposing. So that's really important to keep an eye out for that.
Thank you, agency staff. Thank you, all of our board members who are in the meeting, and certainly all of our attendees. We appreciate you. You're instrumental in regulating this profession, and your input is invaluable to us. Feel free to send us any additional information that you want to by email. We invite you to stay in touch and certainly attend our next stakeholder meeting. And with that, it is 1:21 p.m. and we're adjourned. Thank you, everyone.